Okay, magandang gabi ulit Pilipinas at magandang buhay sa buong mundo. Panibagong take, try natin ulit kung mag-successful siya ngayon kasi kanina nawala yung audio natin. Baka may mga technical nagawa lang tayo na hindi siya Kaya try natin ulit ngayon kung kamusta ba yung audio natin. May audio na ba tayo? Nagawa lang tayo na hindi siya Kaya try natin ulit ngayon kung okay. Okay ang audio natin ngayon. Sana magtuloy-tuloy. Panibagong retake ito. So, start from the start tayo. Start from the start. From the very beginning ulit tayo para buo yung ating reading of RA 7610. Okay. Republic Act of the Philippines, Philippine Commission on Women. Republic Act 7610, Special Protection of Children Against Abuse, Exploitation, and Discrimination Act. Sana magtuloy-tuloy ka. An act providing for stronger deterrence and special protection against child abuse, exploitation, and discrimination, providing penalties for its violation and for other purposes. Okay. Article 1, Title, Policy, Principles, and Definition of Terms. Okay, sana magtuloy-tuloy. I wish. Section 1, Title. This act shall be known as the Special Protection of Children Against Abuse, Exploitation, and Discrimination Act. Section 2, Declaration of Policy and Principles. It is hereby declared to be the policy of the state to provide special protection to children from all forms of abuse, neglect, cruelty, exploitation, and discrimination and other conditions prejudicial their development, provide sanctions for the commission, and carry out a program for prevention and deterrence and crisis intervention in situation of child abuse, exploitation, and discrimination. The state shall intervene in behalf of the child when the parent, guardian, teacher, or person having care or custody of the child fails or is unable to protect the child against abuse, exploitation, and discrimination, or when such acts against the child are committed by the said parent, guardian, teacher, or person having care and custody of the same. It shall be the policy of the state to protect and rehabilitate children gravely threatened or endangered by circumstances which affect or will affect their survival and normal development and over when they have no control. The best interest of children shall be the paramount consideration, and all actions concerning them, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, and legislative bodies, consistent with the principle of first call for children as enunciated in the United Nations Convention of the Rights of the Child. Every effort shall be exerted to promote the welfare of children and enhance their opportunities for a useful and a happy life. Okay, Section 3, Definition of Terms. Children refers to persons below 18 years of age or those over but are unable to fully take care of themselves or protect themselves from abuse, neglect, cruelty, exploitation, or discrimination because of a physical or mental disability or condition. Letter B, child abuse, refers to the maltreatment, whether habitual or not, of the child, which includes any of the following. First, psychological and physical abuse, neglect, cruelty, sexual abuse, and emotional maltreatment. Second, any act by deeds or words which debases, degrades, or demeans the intrinsic worth and dignity of a child as a human being. Third, unreasonable deprivation of his basic needs for survival, such as food and shelter, or fourth, failure to immediately give medical treatment to an injured child resulting in serious impairment of his growth and development or in his permanent incapacity or death. Letter C. Circumstances which gravely threaten or endanger the survival and normal development of children include but are not limited to the following. First, being in a community where there are armed conflict or being affected by armed conflict related activities. Second, working under conditions hazardous to life, safety, and normal, which unduly interfere with their normal development. Third, living in or fending for themselves in the streets or of urban or rural areas without the care of parents or a guardian or basic services needed for a good quality of life. Fourth, being a member of an indigenous cultural community or living under conditions of extreme poverty in an area which is underdeveloped and or lacks or has inadequate access to basic services needed for a good quality of life. Fifth, being a victim of man-made or natural disaster or calamity. Or six, circumstances analogous to those above stated which endanger the life, safety, or normal development of children. Letter D. Comprehensive Program Against Child Abuse, Exploitation, and Discrimination refers to the coordinated program of services and facilities to protect children against, first, child prostitution and other sexual abuse, second, child trafficking, third, obscene publications and indecent shows, fourth, other facts of abuses, and fifth, circumstances which threaten or endanger the survival and normal development of children. Okay, Article 2, Program on Child Abuse, Exploitation, and Discrimination. Section 4, Formulation of the program. There shall be a comprehensive program to be formulated by the Department of Justice and the Department of Social Welfare and Development in coordination with other government agencies and private sector concerned within 1 year from the effectivity of this act to protect children against child prostitution and other sexual abuse, child trafficking, obscene publications, and indecent shows, other acts of abuse and circumstances which endanger child survival and normal development. Okay, Article 3. Let me check, okay lang ba yung aking audio? And proceed tayo sa Article 3. Child prostitution and other sexual abuse. Section 5. Child prostitution and other sexual abuse. Children, whether male or female, who for money, profit, or any consideration, or due to the coercion of influence of any adult, syndicate, or group, indulge in sexual intercourse or lascivious conduct, or deemed to be children exploited in prostitution and other sexual abuse. The penalty of reclusion temporal in its medium period to reclusion perpetua shall be imposed upon the following: those who engage in or promote, facilitate, or induce child prostitution, which include but are not limited to the following: first, acting as a procurer of child prostitute; second, including a person to be a client of a child prostitute by means of written or oral advertisements or other similar means; third, taking advantage of influence or relationship to procure a child as prostitute; fourth, threatening or using violence towards a child to engage him as a prostitute; or fifth, giving monetary consideration, goods, or other pecuniary benefit to a child with intent to engage such child in prostitution. Those who commit the act of sexual intercourse or lascivious contact with a child exploited in prostitution or subject to other sexual abuse, provided that when the victim is under 12 years of age, the perpetrator shall be prosecuted under Article 335, Paragraph 3 for rape and Article 336 of Act Number 3815. As amended, the revised penal code for rape or lascivious contact, as the case may be, provided that the penalty of lascivious conduct when the victim is under 12 years of age shall be reclusion temporal in its medium period, and those who derive profit or advantage therefrom, whether as manager or owner of the establishment where the prostitution takes place, or of the sauna, disco bar, resort, place of entertainment, or establishment serving as a cover, or which engages in prostitution, in addition to the activity for which the license have been issued to the said establishment. Section 6. Attempt to commit child prostitution. There is an attempt to commit child prostitution under Section 5, Paragraph A, hereof when any person who, not being a relative of a child, is found alone with the said child inside the room or cubicle of a house, an inn, hotel, motel, pension house, apartel, or other similar establishments, vessel, vehicle, or any other hidden or secluded area under circumstances which would lead a reasonable person to believe that the child is about to be exploited in prostitution and other sexual abuse. There is also an attempt to commit child prostitution under paragraph B of section 5 hereof when any person is receiving services from a child in a sauna parlor or bath, massage clinic, health club, and other similar establishments. A penalty lower by 2 degrees than that prescribed for the consummated felony under Section 5 hereof shall be imposed upon the principals of the attempt to commit the crime of child prostitution under this act or in the proper case under the revised penal code. Article 4, Child Trafficking. Section 7, Child Trafficking. Any person who shall engage in trading and dealing with children, including but not limited to the act of buying and selling of a child for money or for any consideration or barter, shall suffer the penalty of reclusion temporal to reclusion perpetua. The penalty shall be imposed in its maximum period when the victim is under 12 years of age. Section 8. Attempt to commit child trafficking. There is an attempt to commit child trafficking under Section 7 of this Act when a child travels alone to a foreign country without valid reason, therefore, and without clearance issued by the Department of Social Welfare and Development or written permit or justification from the child's parents or legal guardian. When a person, agency, establishment, or child caring institutions recruits women or couples to bear children for the purpose of child trafficking, or when a doctor, hospital, or clinic, official or employee, nurse, midwife, local civil registrar, or any other person simulates birth for the purpose of child trafficking, or when a person engages in the act of finding children among low-income families, hospitals, clinics, nurseries, daycare centers, or other child-during institutions who can be offered for the purpose of child trafficking. A penalty lower 2 degrees than the prescribed for the consummated felony under Section 7 hereof shall be imposed upon the principals of the attempt to commit child trafficking under this Act. Article 5. Obscene publications and indecent shows. Section 9. Obscene publications and indecent shows. Any person who shall hire, employ, use, persuade, induce, or coerce a child to perform in obscene exhibitions and indecent shows, whether live or in video, or model in obscene publications or pornographic material, or to sell or distribute the said material shall suffer the penalty of prison mayor in its medium period. If the child used as a performer, subject, or seller, distributor is below 12 years of age, the penalty shall be imposed in its maximum period. Any ascendant, guardian, or person entrusted in any capacity with the care of a child who shall cause and or allow such child to be employed or to participate in an obscene play, scene, act, movie, or show, or any other acts covered by this section shall suffer the penalty of prison mayor in its medium period. Article 6. Other acts of abuse. Section 10. Other acts of neglect, abuse, cruelty, or exploitation, and other conditions prejudicial to the child's development. A. Any person who shall commit any other acts of child abuse, cruelty, or exploitation, or to be responsible for other conditions prejudicial to the child's development, including those covered by Article 59 of Presidential Decree Number 603 as amended but not covered by the Revised Penal Code as amended, shall suffer the penalty of prison mayor in its minimum period. Any person who shall keep or have in his company a minor 12 years or under, or when 10 years or more his junior in any public or private place, hotel, motel, beer joint, discotheque, cabaret, pension house, sauna or massage parlor, beach, and or other tourist resort or similar places shall suffer the penalty of prison mayor in its maximum period and a fine of not less than 50,000 pesos, provided that this provision shall not apply to any person who is related within the fourth degree of consanguinity or affinity or any bond recognized by law, local custom and tradition, or acts in the performance of a social, moral, or legal duty. Any person who shall induce, deliver, or offer a minor to anyone prohibited by this act to keep or have in his company a minor as provided in the preceding paragraph shall suffer the penalty of prison mayor in its medium period and a fine of not less than 40,000 pesos. Provided, however, that should the perpetrator be an ascendant, step-parent, or guardian of the minor, the penalty to be imposed shall be prison mayor in its maximum period, a fine of not less than 50,000 pesos, and the loss of parental authority over the minor. Any person, owner, manager, or one entrusted with the operation of any public or private place of accommodation, whether for occupancy, food, drink, or otherwise, including residential places, who allows any person to take along with him to such place or places, any minor herein described shall be imposed a penalty of prison mayor in its medium period and a fine not less than 50,000 pesos and the loss of the license to operate such as place or establishment. Any person who shall induce, coerce, force, or intimidate a street child or any other child to first beg or use begging as means of living, act as conduit or middleman in drug trafficking or pushing, or conduct any illegal activities shall suffer the penalty of prison correctional in its medium period to reclusion perpetua. For purposes of this Act, the penalty for the commission of acts punishable under Articles 248, 249, 262, Paragraph 2, and 263, Paragraph 1 of Act Number 3815 as amended the revised penal code for the crimes of murder, homicide, other intention, mutilation, and serious physical injuries, respectively, shall be reclusion perpetua when the victim is under 12 years of age. The penalty for the commission of acts punishable under Article 337, 339, 340, and 341 of Act No. 3815, as amended, the revised penal code of the crimes of qualified seduction, acts of lasciviousness with the consent of the offended party, corruption of minors, and white slave trade, respectively, shall be 1 degree higher than the imposed by law when the victim is under 12 years of age. The victim of the acts committed under this section shall be entrusted to the care of the Department of Social Welfare and Development. Uh-huh. Article 7. Sanctions for establishments of or enterprises. Section 11. Sanctions for establishments of or enterprises which promote, facilitate, or conduit activities constituting child prostitution and other sexual abuse, child trafficking, obscene publications, and indecent shows and other acts of abuse. All establishments and enterprises which promote or facilitate child prostitution and other sexual abuse, child trafficking, obscene publications, and indecent shows, and other acts of abuse shall be immediately closed, and their authority or license to operate concealed, without prejudice to the owner or manager thereof, being prosecuted under this Act and or the revised penal code as amended or special laws. A sign with the words "off limits" shall be conspicuously displayed outside the establishment or enterprises by the Department of Social and Welfare Development for such period which shall not be less than 1 year, as the department may determine. The unauthorized removal of such sign shall be punishable by prison correctional. An establishment shall be deemed to promote or facilitate child prostitution and other sexual abuse, child trafficking, obscene publications, and indecent shows, and other acts of abuse if the acts constituting the same occur in the premises of said establishment under this Act or in violation of the revised penal code as amended. An enterprise such as a sauna, travel agency, or recruitment agency which promotes the aforementioned acts as part of a tour for foreign tourists, exhibits children in a lewd or indecent show, provides child measures for adults of the same or opposite sex, and said services include any lascivious contact with customers or solicits children or activities constituting the aforementioned act shall be deemed to have committed the acts penalized herein. Article 8. Working Children. Section 12. Employment of Children. Children below 15 years of age may be employed except when a child works directly under the sole responsibility of his parents or legal guardian and where only members of the employer's family are employed, provided, however, that this employment neither endanger his life, safety, and health and morals, nor impairs his normal development. Provided further, that the parent or legal guardian shall provide the said minor child with the prescribed primary or secondary education, or when a child's employment or participation in public and entertainment or information through cinema, theater, radio, or television is essential, provided the employment contract concluded by the child's parents or guardian with the express agreement of the child concerned, if possible, the approval of the Department of Labor and Employment, provided that the following requirements in all instances are strictly complied with. A. The employer shall ensure the protection, health, safety, and morals of the child. B. The employer shall institute measures to prevent the child's exploitation or discrimination, taking into account the system and level of remuneration and the duration and arrangement of working time. And C. The employer shall formulate and implement, subject to the approval and supervision of competent authorities, a continuing program for training and skill acquisition of the child. In the above exceptional cases where any such child may be employed, the employer shall first secure, before engaging child, such a work permit from the Department of Labor and Employment, which shall ensure observance of the above requirement. The Department of Labor and Employment shall promulgate rules and regulations necessary for the effective implementation of this section. Section 13. Non-formal education for working children. The Department of Education, Culture, and Sports shall promulgate a course designed under its non-formal education program aimed at promoting the intellectual, moral, and vocational efficiency of working children who have not undergone or finished elementary or secondary education. Such course design shall integrate the learning process deemed most effective under given circumstances. Section 14. Prohibition of the employment of children in certain advertisements. No person shall employ child models in all commercials or advertisements promoting alcohol, alcoholic beverages, intoxicating drinks, tobacco, and its byproducts and violence. Section 15. Duty of employer. Every employer shall comply with the duties provided in Article 108 and 109 of Presidential Decree number 603. Section 16. Penalties. Any person who shall violate any provision of this article shall suffer the penalty of a fine not less than 1,000 pesos, but not more than 10,000 pesos, or imprisonment of not less than 3 months, but not more than 3 years, or both at the discretion of the court, provided that, in case of repeated violations of the provisions of this article, the offender's license to operate shall be revoked. Article 9. Children of indigenous cultural communities. Section 17. Survival, protection, and development. In addition to the rights guaranteed to children under this Act and other existing laws, children of indigenous cultural communities shall be entitled to protection, survival, and development consistent with the customs and traditions of their respective communities. Section 18. System of and access to education. The Department of Education, Culture, and Sports shall develop and institute an alternative system of education for children of indigenous cultural communities, which culture-specific and relevant to the needs of an existing situation in their communities. The Department of Education, Culture, and Sports shall also accredit and support non-formal but functional indigenous educational programs conducted by non-government organizations in said communities. Section 19. Health and Nutrition. The delivery of basic social services in health and nutrition to children of indigenous cultural communities shall be given priority by all government agencies concerned. Hospitals and other health institutions shall ensure that children of indigenous cultural communities are given equal attention. In provision of health and nutrition services to children of indigenous cultural communities, indigenous health practices shall be respected and recognized. Section 20, Discrimination. Children of indigenous cultural communities shall not be subjected to any and all forms of discrimination. Any person who discriminate against children of indigenous cultural communities shall suffer a penalty of arresto mayor in its community period and a fine of not less than 5,000 pesos, not more than 10,000 pesos. Section 21, Participation. Indigenous cultural communities, through their duly designated or appointed representatives, shall be involved in planning, decision-making, implementation, and evaluation of all government programs affecting children of indigenous cultural communities. Indigenous constitutions shall also be recognized and respected. Article 10. Children in situations of armed conflict. Section 22. Children as zone of peace. Children are hereby declared as zone of peace. It shall be the responsibility of the state and all other sectors concerned to resolve armed conflicts in order to promote the goal of children as zone of peace. To attain this objective, the following policies shall be observed. A. Children shall not be object of attack and shall be entitled to special respect. They shall be protected from any form of threat, assault, torture, or other cruel, inhuman, or degrading treatment. B. Children shall not be recruited to become members of armed forces of the Philippines of its civilian units or other armed groups, nor be allowed to take part in the fighting or used as guides, couriers, or spies. C. Delivery of basic social services such as education, primary health, and emergency relief services shall be kept unhampered. The safety and protection of those who provide services, including those involved in fact-finding missions from both government and non-government institutions, shall be ensured. They shall not be subjected to undue harassment in the performance of their work. And E. Public infrastructure such as schools, hospitals, and rural health units shall not be utilized for military purposes such as command posts, barracks, detachments, and supply depot. And F. All appropriate steps shall be taken to facilitate the reunion of families temporarily separated due to armed conflict. Section 23. Evacuation of children during armed conflict. Children shall be given priority during evacuation as a result of armed conflict. Existing community organizations shall be tapped to look after the safety and well-being of children during evacuation operations. Measures shall be taken to ensure the children evacuated are accompanied by persons responsible for their safety and well-being. Section 24. Family life and temporary shelter. Whenever possible, members of the same family shall be housed in the same premises and given separate accommodation from other evacuees and provided with facilities to lead a normal family life. In place of temporary shelter, expectant and nursing mothers and children shall be given additional food in proportion to their physiological needs. Whenever feasible, children shall be given opportunities for physical exercise, sports, and outdoor games. Section 25. Rights of children arrested for reasonable related to armed conflict. Any child who has been arrested for reason related to armed conflict, either as combatant, courier, guide, or spy is entitled to the following rights. A. Separate detention from adults except where families are accommodated as family units. B. Immediate free legal assistance. C. Immediate notice of such arrest to the parents or guardians of the child. And D. Release of the child or recognizance within 24 hours to the custody of the Department of Social Welfare and Development or any responsible member of the community as determined by the court. If after hearing the evidence in the proper proceedings, the court should find that the aforesaid child committed the acts charged against him, the court shall determine the imposable penalty, including any civil liability chargeable against him. However, instead of pronouncing judgments of conviction, the court shall suspend all further proceedings and shall commit such child to the custody of care of the Department of Social Welfare and Development or to any training institutions operated by the government or duly licensed agencies or any responsible person until he has reached 18 years of age or for a shorter period as the court may deem proper after considering the reports and recommendations of the Department of Social Welfare and Development or the agency or responsible individual under whose care has been committed. The aforesaid child shall subject to visitation and supervision by a representative of the Department of Social Welfare and Development or any duly licensed agency or such other officer as the court may designate subject to such condition as it may prescribe. The aforesaid child whose sentence is suspended can appeal from the order of the court in the same manner as appeals in criminal cases. Section 26. Monitoring and reporting of children in situations of armed conflict. The chairman of the barangay affected by armed conflict shall submit the names of children residing in said barangay to the municipal social welfare and development officer within 24 hours from the occurrence of the armed conflict. Article 11. Remedial procedures. Section 27. Who may file a complaint? Complaints on cases of unlawful acts committed against the children as enumerated herein may be filed by the following: A. Offended party. B. Parents or guardians. C. Ascendant or collateral relative within the third degree of consanguinity. D. Officer, social worker, or representative of a licensed child caring institution. E. Officer or social worker of the Department of Social Welfare and Development. F. Barangay chairman. Or letter G. At least 3 concerned responsible citizens where the violation occurred. Ayan. Siya sabi na Attorney Aaron. Section 28. Protective custody of the child. The offended party shall be immediately placed under the protective custody of the child of the Department of Social Welfare and Development pursuant to Executive Order Number 56, Series of 1986. In the regular performance of this function, the officer of the Department of Social Welfare and Development shall be free from any administrative, civil, or criminal liability. Custody proceedings shall be in accordance with the provision of Presidential Decree Number 603. Section 29. Confidentiality. At the instance of the offended party, his name may be withheld from the public until the court acquires jurisdiction over the case. It shall be unlawful for any editor, publisher, and reporter or columnist in case of printed materials, announcer or producer in case of televisions and radio broadcasting, producer and director of the film in case of movie industry, to cause undue and sensationalized publicity of any case of violation of this act, which results in the moral degradation and suffering of the offended party. Section 30. Special Court Proceedings. Cases involving violation of this act shall be heard in the chambers of the judge of the regional trial court duly designated as juvenile and domestic court. Any provision of existing law to the contrary notwithstanding, and with the exception of habeas corpus, election cases, and cases involving detention prisoners and persons covered by Republic Act number 4908, all courts shall give preference to the hearing or disposition of cases involving violations of this act. Article 12. Common Penal Provisions. Section 31. Common Penal Provisions. The penalty provided under this act shall be imposed in its maximum period if the offender has been previously convicted under this act. B. When the offender is a corporation, partnership, or association, the officer or employee thereof who is responsible for the violation of this act shall suffer the penalty imposed in its maximum period. C. The penalty provided herein shall be imposed in its maximum period when the perpetrator is an ascendant, parent, guardian, step-parent, or collateral relative within the second degree of consanguinity or affinity, or a manager or owner of an establishment who has no license to operate or its license has expired or has been revoked. Letter D. When the offender is a foreigner, he shall be deported immediately after service of sentence and forever barred from entry to the country. Letter E. The penalty provided for in this act shall be imposed in its maximum period if the offender is a public officer or employee, provided, however, that if the penalty imposed is reclusion perpetua or reclusion temporal, then the penalty of perpetual or temporary absolute disqualification shall be imposed, provided finally that if the penalty imposed is prison, correctional, or arresto mayor, the penalty of suspension shall also be imposed. And F. A fine to be determined by the court shall be imposed and administered as a cash fund by the Department of Social Welfare and Development and disbursed for the rehabilitation of each child victim or any immediate members of his family if the latter is the perpetrator of the offense. Article 13. Final Provisions. Section 32. Rules and Regulations. Unless otherwise provided in this Act, the Department of Justice, in coordination with the Department of Social Welfare and Development, shall promulgate rules and regulations of the effective implementation of this Act. Such rules and regulations shall take effect upon their publication in two national newspapers of general circulation. Section 33. Appropriations. The amount necessary to carry out the provision of this Act is hereby authorized to be appropriated in the General Appropriations Act of the year following its enactment into law and thereafter. Section 34. Separability Clause. If any provision of this Act is declared invalid or unconstitutional, the remaining provisions not affected thereby shall continue in full force and effect. Section 35. Repealing Clause. All laws, decrees, or rules inconsistent with the provision of this Act are hereby repealed or modified accordingly. And Section 36, Effectivity Clause. This act shall take effect upon completion of its publication in at least 2 national newspapers of general circulations. So, signed, Neptalia Gonzalez, President of the Senate. Signed, Ramon Metra, Speaker of the House of Representatives. This act, which is a consolidation of House Bill numbers 6946, 29431, 35354, and Senate Bill number 1209, was finally passed by the House of Representatives and the Senate February 7, 1992. Signed, Anacleto Badoy Jr., Secretary of the Senate, and signed Camilo Sabio, Secretary General, House of Representatives, and signed President of the Philippines, Corazon C. Aquino. So, ito po ang ating buong buod ng ating Republic Act 7610. So, spread po natin ito kasi dito po nag-base si Atty. Aaron. At least alam po natin ang nilalaman ng special protection for children. So, nawa may natutunan tayo at ating ibahagi ito para mas marami pang makakaalam at marami pang mga concerned citizen ang makakaalam ng obligasyon nila na tayo pala ay kahit hindi natin po kaano-ano ang mga kabataan sa paligid natin, as long as we witnessed it, then at least 3 of us concerned citizen can help to get justice for the children kung hindi kaya ng magulang seek justice para sa bata. So hanggang ngayon, dito na lang po. Please share and subscribe na rin sa channel na ito kung sa tingin nyo ito ay nakakatulong sa inyo. Hanggang sa muli, maraming salamat sa makapanood ng video ito.